Writers and actors are striking in sunny California, and a movie studio just so happened to trim the city's trees that were providing shade to the protesters. You know what that means. It finally happened. We're talking tree law, baby. Eee, tree law, it finally happened, yay! All right, so the city of Los Angeles has fined NBC Universal $250 after the company trimmed ficus trees that striking writers and actors were using for shade while picketing at the Universal Studios lot. Was this a deliberate attempt to hurt the strikers during an unprecedented heat wave, as the mayor and strikers alleged? And if so, then why is Universal only getting a slap on the wrist? Or was it just a simple misunderstanding and coincidence? Well, welcome to the wild world of tree law. Now, on July 17th, writer and SAG member Chris Stevens shared a photo of a row of ficus trees outside of the Universal Studios lot in Los Angeles. Quote, quick shout out to the good people at Universal Pics for trimming the trees that gave our picket line shade right before 90+ degree week. It appeared that the trees had their branches and leaves trimmed down over the weekend. When strikers showed up for the picket line on Monday, they found that their shade was gone. And in the photo, you can see the before and after that Stevens referred to. Stevens and the other strikers suggested that the tree trimming was a pretext to take shade from striking SAG-AFTRA workers. The union's 160,000 members went on strike in July, along with the 11,000 Writers Guild of America members who have been on strike since May. Now, in most cities, you can't just trim or remove trees without a permit. As most people on the internet seem to know. In Los Angeles, these trees are along a sidewalk that is considered public property. Their maintenance is under the jurisdiction of the Urban Forestry Division of the Bureau of Street Services. The Urban Forestry Division manages nearly 700,000 street trees, growing along 6,500 miles of public roads, making the city of Los Angeles' street tree population the largest urban forest in the nation and possibly the world. And Streets LA has a website where you can actually look up all 700,000 trees in the city. And when I type in 3801 Barnum Boulevard into the search site, it pulls up those that line the streets that are in question here. And since so many people have a passion for tree law, yes, I see you, 78,000 members of Reddit's Tree Law Forum, let me do a quick rundown on this apparently intoxicating legal speciality. In the United States, state and local governments have jurisdiction over tree laws. Tree law governs issues like who owns trees, how neighbors handle tree disputes, whether a tree is on government property, when trees become hazardous, and whether a person can cut down trees on their own property. Now, generally, if your neighbor's tree branches or roots cross onto your property, you can cut them down if they're creating a hazard. However, if you damage your neighbor's tree in the process, you might have to pay for the damage. Now, tree law is a very thorny issue, but if you need to branch out and get a great lawyer, my firm, the Eagle team, can help. If you've been in a car crash, suffered a data breach, or have Social Security disability issues, we can represent you or help find you the right attorney who can. Just click on the link in the description for a free consultation with my team, because you don't just need a legal team, you need the Eagle team. The link is below. Now, Los Angeles has special rules for protected trees, covering mostly oak trees that are indigenous to California. Illegal pruning or willful damage to protected oak trees can result in a $10,000 fine and or 6 months in jail. The city also protects heritage trees, which are, quote, individual trees of any size or species that are specifically designated as heritage because of their historical, commemorative, or horticultural significance. There are steep fines for damaging trees with historical significance, like the Tuna Canyon Detention Station's Tahunga Oak Grove. These trees are the last remnant of a World War II era Japanese detention camp. The ficus trees outside of Universal Studios lot located at 3801 Barnum Boulevard are not protected or historical. Instead, they are considered, quote, a parkway tree. A parkway tree is a tree that is planted by Public Works or the developer who built the building adjacent to the edge of the roadway. Now, for parkway trees, the city follows the recommendations of the International Society of Arboriculture, which generally recommends that most trees be trimmed during the dormant season. The dormant season for ficus trees is fall or winter. Arborists were also concerned about the way the Universal trees were trimmed because they appear to have been topped. Now, topping is the removal of the top of the central stem of a tree, called the leader, as well as the upper main branches. Now, Los Angeles has formally adopted the American National Standard Institute's pruning standards. The ANSI says, quote, topping and lion's tailing shall be considered unacceptable pruning practices for trees. Universal told Deadline to, quote, prune these trees annually at this time of the year. Though one Constantine Anthony, a member of SAG-AFTRA, questioned whether this was true.
We can't find any work orders done for this particular tree trimming, which is problematic. In Southern California, we have a lot of laws governing trees. Normally, you don't trim until October. And in fact, the exact same style and type of tree, about 200 feet this way, are not trimmed but those aren't providing shade to the picketers, are they?
LA City Controller Kenneth Mejia investigated the matter and said his office hadn't given Universal a tree trimming permit in 3 years. He concluded that Universal should have gotten a permit. And Mejia fined NBC Universal $250 because that is the maximum penalty allowed for a first-time offender. He tweeted that, quote, Streets LA fines all first-time offenders, regardless of the number of trees at issue, a $250 penalty. If violations continue, the fines can grow to $1,000. If trees are found to be significantly damaged, LA can require the offenders to plant 2 trees per damaged tree. Now, I should note, as a longtime former resident of Los Angeles, I've seen these kinds of trees all over the city of LA and often pruned in this manner. I have no idea whether people are getting permits for this kind of thing, but it also seems like a lot of people tend to prune these kinds of trees in the summertime. So at least from that aspect, anecdotally, in my own personal experience, it doesn't seem that out of character. And in this case, Streets LA determined that the trees didn't suffer significant damage and would easily recover in 6 to 12 months. Mejia pointed out that LA's 12 tree inspectors have the impossible job of monitoring over 700,000 trees, and he said the system isn't working as intended. And as much as I'd love to demonize the movie studios here, another issue with these kinds of trees is that they grow so fast that they often tend to interfere with traffic. So it wouldn't be surprising if one wanted to err on the side of trimming the trees rather than letting them grow wild, which literally can impact the cars that are driving by. But the city's fine here isn't the end of the story between the unions and Universal. Both SAG-AFTRA and the WGA filed formal unfair labor practice charges against Universal. An unfair labor practice, referred to as a ULP, is an action by an employer or a union that violates the National Labor Relations Act. And the NLRA was passed in 1935. Its aim is to encourage collective bargaining between workers and employers. And the NLRA gives employees the fundamental right to seek better working conditions without fear of retaliations. Now, classic examples of a ULP by an employer include firing or penalizing employees who exercise any of the rights under the NLRA, including the right to picket an employer, as those striking actors and writers were doing outside of the Universal lot. And the SAG-AFTRA charge says, quote, Universal was interfering with lawful picketing activity by designating as picketing locations areas where the public sidewalks have been covered up with construction fencing, forcing picketers to patrol in busy streets with significant car traffic, where 2 picketers have already been struck by a car, and by refusing to provide K-rail barriers to establish pedestrian walkways for picketers to use after Los Angeles Police Department advised the employer weeks ago in the interest of public safety to do so. The union said that this was suspiciously timed construction and that the loss of tree shade during a record heat wave has forced SAG-AFTRA to determine that it cannot safely send its members to picket at NBC Universal. Now, Universal said it regretted that its decision, quote, created unintended challenges for demonstrators. That was not our intention. In partnership with licensed arborists, we have pruned those trees annually at this time of the year to ensure that the canopies are light ahead of the high wind season. Now, it's certainly possible that this was simply a coincidence and not a ULP, we just don't know. But it's also important to look at why the unions are striking in the first place. Because for the first time since Ronald Reagan was the union boss, yes, that is actually a thing that happened, the unions representing actors and writers are staging a strike at the same time. The actors and writers are negotiating with the Alliance of Motion Picture and Television Producers, or AMPTP, and the AMPTP represents major studio bosses and producers such as Sony, Universal, Paramount, Walt Disney Studios, Warner Brothers, plus major streamers like Netflix, Amazon, and Apple TV+. And the strikers are concerned about a number of different topics, including low pay, residuals, streaming, and the use of AI. And those topics probably require their own dedicated video. And while YouTubers aren't generally members of these unions, we definitely know what it feels like to be screwed over by movie studios and television producers. So if you'd like to support the unions in their negotiations, you can donate to the link that's down in the description, including SAG-AFTRA's Emergency Financial Assistance Program, which gives emergency financial aid to members with great urgent need. And their Green Envelope Grocery Aid provides grocery assistance to striking writers and actors. And if you know any striking actors or writers, you can get them groceries directly with today's sponsor, HelloFresh. Absolutely everyone loves HelloFresh. And if you already have a HelloFresh subscription, why not get a subscription for one of these striking writers or actors? Because HelloFresh is a great way to eat delicious fresh food while still being healthy. It's a great way to get back into a diet or just eat great food. In fact, HelloFresh has a whole variety of calorie smart, carb smart, pescatarian, and veggie options. You can customize it how you like too. HelloFresh delivers fresh, quality produce from the farm to your door in less than a week. Right now, they have summer favorites from backyard bratwurst bars to tangy key lime pie. Now, I'm a do-it-yourself person, and I have to say, I was initially pretty skeptical about HelloFresh. I'm a pretty good cook, so I didn't think that I needed the help, but actually, I loved it. Even for an experienced cook, HelloFresh delivers new ingredients and recipes that I would never try on my own. And of course, everything was delivered straight to my door, so I didn't have to do any shopping. The produce actually gets to you faster than a grocery store, so it arrives at peak freshness and flavor. And it's also super easy to save time. HelloFresh cuts out the meal planning and prep, so the recipes only take 20 to 30 minutes to cook. Literally less time to cook than it would normally take to do the shopping. And HelloFresh is 25% cheaper than takeout. So if you'd like to try HelloFresh, go to HelloFresh.com and use the code LegalEagle50 at checkout for 50% off plus free shipping. Yes, you can actually get 50% off plus free shipping by clicking on the link that's on screen or down in the description. So click on the link below and use the code LegalEagle50 at checkout. After that, click on this link over here for more Legal Eagle, or I'll see you in court. You know, it's funny, usually in a domestic defamation dispute like this, the internet has all kinds of opinions, but they've been completely silent about Johnny Depp and Amber Heard. It's weird. Oh, okay. Yeah, so Johnny Depp is suing Amber Heard. She is suing him at exactly the same time. This is all incredibly crazy. And this latest suit and countersuit is already turning into a circus. Of course, for Hollywood celebrities leading public lives, it seems like there's no such thing as a truly private matter. And this has certainly been the case for Amber Heard, who has publicly accused her ex-husband, Johnny Depp, of subjecting her to years of physical and emotional abuse during their marriage. And Depp, for his part, has vehemently denied the allegations, accusing Heard of defaming him with fabricated claims while portraying Heard as the real abuser. And while Heard has primarily aired her grievances to the media, Depp has opted to take his fight to the courtroom in both the UK and the state of Virginia. Now, determining the truth of domestic violence allegations is invariably a challenging prospect. As a result, the public's response to these allegations has been incredibly polarizing, with Heard and Depp having their own supporters and detractors alike. So, Legal Eagles, let's talk about the Johnny Depp-Amber Heard saga. We'll cover the facts leading up to the decades-long dispute between the former celebrity couple, review the multi-million-dollar defamation lawsuits in the UK and the US that have been brought as a result, and talk about how Johnny Depp can sue twice for basically the same thing. Now, the former Hollywood couple's Virginia courtroom confrontation is the culmination of 10 years of love, heartbreak, and abuse allegations between the Pirates of the Caribbean actor and the Justice League actress. Here is the timeline of how this feud leapt from the tabloids to the courtroom. Now, in 2012, Johnny Depp and Amber Heard began dating following Depp's split from his longtime partner, French model, actress, singer Vanessa Paradis. Depp and Paradis dated for 14 years and they shared 2 children together. In February of 2015, Depp and Heard officially tied the knot, but as quickly as the pair fell in love, things fell apart just as swiftly. On May 21st, 2016, the LAPD responded to a Saturday night call in which Heard alleged domestic abuse. Law enforcement officials at the time stated they found, quote, no evidence of any crime, and Heard did not file any charges. On May 23rd, 2016, Heard officially filed for divorce from Depp, citing irreconcilable differences. 4 days later, Heard appeared in a Los Angeles court with a bruised cheek to request a temporary restraining order against Depp. In a sworn declaration, Heard alleged that her then husband, 23 years her senior, had, quote, violently attacked her and thrown a cell phone at her face with extreme force. Photographs submitted to the court show Heard with a large bruise on her face, along with broken bottles, picture frames, and shattered glass on the floor. Heard alleges that, quote, during the entirety of our relationship, Johnny has been verbally and physically abusive, end quote. Heard further claimed that she, quote, endured excessive emotional, verbal, and physical abuse, which has included angry, hostile, humiliating, and threatening assaults to me whenever I questioned his authority or disagreed with him. Now, in her filings, Heard recounted an alleged April 21st assault wherein Depp allegedly came home drunk as Heard's birthday party was ending, threw a champagne bottle at a wall, grabbed her hair, violently shoved her to the floor, and Heard also alluded to, quote, one severe incident in December 2015 when I truly feared for my life. People magazine would later publish a photo purportedly from this incident. In opposition to these motions, Depp's lawyers claimed the allegations were false and accused Heard of, quote, attempting to secure a premature financial resolution by alleging abuse. On May 27th of that year, the judge granted Heard's temporary restraining order, ordering Depp to stay at least 100 yards away and avoid all contact until a June 17th follow-up hearing that would decide whether the order should be made permanent. But hours before the scheduled hearing, Heard and Depp released a joint statement announcing that they had resolved their dispute. Quote, our relationship was intensely passionate and at times volatile, but always bound by love. Neither party has made false accusations for financial gain. There was never any intent of physical or emotional harm. Now, in August of 2016, Depp and Heard reached a divorce settlement, with Heard allegedly pledging to donate $7 million to the American Civil Liberties Union and the Children's Hospital of Los Angeles. In August of 2021, a New York judge partially granted Depp's motion to force the ACLU to produce documents to show if she did in fact donate the $7 million, a fact that remains contested by Depp. And after the divorce was finalized in January of 2017, Depp's attorney Laura Wasser released the following statement, quote, "We're pleased to put this unpleasant chapter in Mr. Depp and his family's lives behind them. Having his request for entry of the dissolution of judgment granted today made it a particularly lucky Friday the 13th. Now, while Depp's attorneys declared their client's intention to put this chapter behind him, the British tabloids would not extend Mr. Depp such a courtesy. Which takes us to how the UK lawsuit got filed. Now, following the divorce, both Heard and Depp continued to pursue their respective acting careers. Heard reprised her role as Mara from Aquaman for Joss Whedon's Justice League in 2017, while Depp returned as Captain Jack Sparrow for the 5th Pirates of the Caribbean installment. But as Depp was preparing to reprise his role as the eponymous villain in J.K. Rowling's Fantastic Beasts: The Crimes of Grindelwald, The Sun, a British tabloid, fired a shot across the pond by rehashing Heard's abuse allegations. On April 27, 2018, the Sun executive editor Dan Wooten published an article entitled "Gone Potty, How Can J.K. Rowling Be Genuinely Happy Casting Wife-Beater Johnny Depp in the New Fantastic Beast Film?" Writing that, quote, "Overwhelming evidence was filed to show Johnny Depp engaged in domestic violence against his wife Amber Heard." Wooten accused the Harry Potter author of, quote, "providing Depp total rehabilitation in the eyes of the movie industry by allowing Depp to star in the Fantastic Beasts sequel." Now, Depp's response to the article was swift. On June 1st, 2018, Depp sued the parent company that publishes The Sun in England for libel, demanding a minimum of $200,000 plus legal fees. Depp's attorneys argued the article defamed him by presuming the actor was guilty of domestic violence against his former wife, highlighting the use of the term wife-beater. Now, Depp's counsel maintained that these, quote, "reputation-destroying and career-ending allegations were untrue and caused the actor, quote, serious harm," the threshold standard for defamation in England. In its defense, The Sun's parent company argued that there was sufficient evidence to show that Depp was, quote, "violent towards Miss Heard on multiple occasions during their relationship, making the term wife-beater an accurate statement." And in support of its claims, the company relied on 14 alleged incidents of physical abuse against Heard that purportedly occurred between 2013 and 2016. Though neither Depp nor Heard were on trial, the case was essentially a dress rehearsal for the pair's Virginia defamation trial, with both Depp and Heard giving live testimony detailing an array of graphic allegations. When Depp took the stand, he acknowledged wide-ranging drug problems, which he referred to as, quote, "the monster." But Depp accused Heard of making up allegations and insisting that he was, quote, "not a violent person, especially with a woman," a characterization that was backed up in sworn statements from former partners Winona Ryder and Vanessa Paradis. Depp portrayed Heard as the aggressor in the relationship, accusing her of repeatedly belittling him and frequently turning physically violent during their tumultuous marriage, saying, quote, "it was sort of a rapid-fire, sort of endless parade of insults. Quote, looking at me like I was a fool and I was having difficulty in my mind, of course, and in my heart dealing with that sort of barrage." Depp further alleged that Heard would sometimes strike out in anger or frustration. And regarding an alleged headbutting incident in December of 2015 at his LA penthouse, Depp testified he was trying to hold Heard back from hitting him and their foreheads collided by accident. Depp also detailed a purported March 2015 argument in Australia that led to part of his finger being sliced off due to a thrown vodka bottle. Depp contended that Heard saw him drinking for the first time in a while, and she threw a bottle of vodka that narrowly missed his head before throwing a larger bottle that did strike his head. Photos provided by Depp's counsel purported to show Depp with a bloody finger and a cigarette burn on his face. For her part, Heard denied injuring Depp, contending that her ex severed his own finger during a drug and alcohol binge after repeatedly smashing a wall-mounted phone against the wall. Heard testified that Depp, fueled by drugs and alcohol, hit, slapped, and shoved Heard, pulling her hair and threw bottles, quote, "like grenades" at Heard at various incidents between 2013 and 2016. On cross-examination, Heard denied the characterization of Depp's lawyers that she was the one who struggled with drugs and alcohol, that she was the one who abused him, and that she was the one who was controllingly manipulative, not Depp. Now, under cross-examination, Depp admitted it was possible that he destroyed the phone, stating, quote, "I remember ripping the phone off the wall." Depp also admitted that he had previously taken responsibility for severing his finger, though Depp claimed that he was only trying to protect Heard when he had to tell the production company the injury prevented him from working on set. And Depp also confirmed that he wrote messages for Heard in blood, paint, and lipstick, including, quote, "I love you," and, quote, "good luck," which he did to indicate he felt the relationship was over. And in a trial that had the couple airing out their dirty laundry, Depp also detailed an alleged incident involving literal dirty laundry. Supposedly on the night of Heard's birthday party in April of 2016, Depp says he arrived late due to a meeting he was attending. Depp testified that Heard was furious with him, hitting him multiple times after the party ended before he left and spent the night at another home. Depp said that he planned to retrieve items the next morning after Heard left for Coachella, but was told by someone at the home who texted him a photo not to return because there was poop in the bed. Quote, "It was a photograph of the bed, our bed, and on my side of the bed was human fecal matter, so I understood why it wasn't a good time to go down there." He continued, "My initial response to that was, I laughed. It was so outside, it was so bizarre, and so grotesque that I could only laugh." Depp had previously claimed in a written statement that Heard or one of her friends were the culprit and alleged that Heard had called this, quote, "just a harmless prank." But Depp said that incident was when he knew their marriage was over, and a month later, Heard filed for divorce. Heard has denied any role in this whodunit, suggesting the story is fabricated simply to humiliate her. So yeah, the British trial was incredibly colorful. And after hearing all of the evidence, the UK court sided with the Sun and rejected Depp's libel claims. In his November 2020 opinion, Justice Andrew Niccol concluded that the Sun had met its burden of proof and that the Sun's allegations that Depp engaged in unprovoked attacks and violent conduct against his then wife that caused her to be in fear for her life were true, quote, "on the balance of the probabilities," meaning the abuse allegations were more likely than not to be true. The justice did not accept Depp's characterization of Heard as a gold digger who had, quote, "constructed a hoax," and as an insurance policy in the event the marriage fell apart. Among the incidents the judge found to be substantially true were the two events alluded to in Heard's 2016 application for domestic violence restraining order, the May 2016 assault with Depp's phone, and the severe December 2015 incident where Depp allegedly threw a decanter at Heard in the penthouse, headbutted her, and pulled large chunks of hair from her scalp before an appearance on James Corden's Late Late Show. And the justice did not find Depp's claim that Heard was responsible for severing his fingertip to be credible. And as for the poop in the bed incident, well, the judge blamed the dog. Quote, "For what it's worth, I consider it unlikely that Miss Heard or one of her friends was responsible," reasoning in part that Depp was out of the house at the time of the incident and Heard was the one likely to suffer from the effects. The judge concluded, quote, "It was therefore a singularly ineffective means for Miss Heard or one of her friends to get back at Mr. Depp." Your mileage may vary on that reasoning. In response to the ruling, Depp's representative stated they found the decision, quote, "as perverse as it is bewildering," and immediately announced their intention to appeal. But in March of 2021, Depp's appeal was rejected, and the Court of Appeals ruled that the lower court case was, quote, "full and fair," and the trial judge's conclusions, quote, "have not been shown to even arguably be vitiated by any error or approach of mistake of law," and concluded the appeal has no real prospect of success and that there is no other compelling reason for it to be heard. On appeal, Depp's counsel had argued they did not get a fair hearing and that Heard was an unreliable witness. And as evidence of her unreliability, Depp's counsel asserted that Heard has not kept her promise to donate her $7 million divorce settlement to charity. And the fallout from Depp's spectacular defeat was immediate. Following the November ruling, Depp announced he was leaving the Fantastic Beasts franchise after Warner Bros. Requested his resignation. And that takes us to the good old US of A, because what makes Depp's defeat so notable is that the odds of prevailing on a libel claim are much higher in England than in the US. In England, the party accused of defamation has the burden of proving that their claim is, quote, "substantially true." Now, that's the opposite in the US, where the defamed person has the burden of proving that the libelous statements are false. Another reason US defamation cases are hard to win is that public figures like Depp must prove the defamatory statements were made with actual malice, meaning that they were published with knowledge of being false or reckless disregard for their truth or falsity. Again, actual malice has nothing to do with not liking a person. It is an evidentiary standard, and it's not particularly well named. It's a legal term of art. And even with these built-in advantages, Depp still lost twice in the UK. In the face of Depp's double defeat, some have characterized Depp's legal strategy as a complete flop. And remember, not only have 2 British courts found Heard's abuse allegations to be substantially true, but Depp's efforts have had the unintended Streisand effect of amplifying these allegations. After all, if not for Depp's multiple lawsuits, there would be no reason for this channel to make a video on this controversy to the millions of LegalEagle subscribers. It's a case of life imitating art, I guess. But Depp's defenders insist that the British trial was not fairly decided, that new evidence has since come forward that paints a different picture, particularly with new audio that purports to show Heard admitting to abusing Depp. So, after all of this, we find ourselves back on American soil as Depp attempts another bite at the defamation apple, hoping this time he will be vindicated. And particularly at issue in the American trial is an op-ed that Amber Heard published on December 18th, 2018, 6 months after Depp filed the UK libel action, where she published in the Washington Post an article entitled, "I spoke up against sexual violence and faced our culture's wrath. That has to change." Heard wrote, quote, "Like many women, I had been harassed and sexually assaulted by the time I was of college age, but I kept quiet. I did not expect filing complaints to bring justice, and I didn't see myself as a victim. Then, 2 years ago, I became a public figure representing domestic abuse, and I felt the full force of our culture's wrath for women who speak out." And in March 2019, Depp responded to the op-ed by filing a $50 million defamation lawsuit against his ex-wife, contending Heard's article contained, quote, "categorically and demonstrably false claims of domestic abuse." Quote, "The op-ed depended on the central premise that Miss Heard was a domestic abuse victim and that Mr. Depp perpetrated domestic violence against her." Depp's lawyers also wrote in the complaint, quote, "Her allegations are part of an elaborate hoax to generate positive publicity for Miss Heard and advance her career." The complaint, which again are just allegations from one side, charged that Heard had incalculably damaged the actor's reputation and derailed his career, highlighting that Disney fired Depp from the Pirates of the Caribbean franchise 4 days after the publication of Heard's article. And though the article does not mention Depp by name, a party alleging defamation need not be specifically named so long as there are enough identifying facts the person reading it would reasonably understand that the statements refer to the plaintiff. And in August of 2020, Heard countersued for $100 million, arguing that Depp's denial of the abuse effectively accused Heard of committing perjury to obtain the 2016 domestic violence restraining order, which defamed her character. Heard also accused Depp of orchestrating an online smear campaign against Heard in violation of Virginia's laws against online harassment. Now, some of you might be wondering why this case is going to trial at all, given that it appears to have already been litigated in another forum in the UK. And there is a principle of law that prevents relitigation of the same cause of action in a second lawsuit between the same parties. It's called claim preclusion, also referred to as res judicata, which is Latin for a matter decided. Basically, it's like double jeopardy, but for civil suits. And there's also issue preclusion, or collateral estoppel, preventing a party from relitigating an issue once a court has already ruled on it. Now, Heard's lawyers tried to get the US lawsuit thrown out because of some of the claims that were already decided in the UK, but the judge denied the motion. Like most things in law, there were arguments on both sides of these issues. And in particular, Amber Heard was not a defendant in the UK case. She was only a witness. Depp was a party though, and he appealed his case to the highest court in the UK and lost. But because Heard wasn't a party in the UK case, remember Depp sued the Sun and the Sun's parent company, and a few other reasons, Amber Heard was not able to benefit from claim preclusion and res judicata to prevent Depp from being able to sue in Virginia. And then also, American courts reject foreign judgments that don't live up to American standards of free speech. And there's a law, the Securing the Protection of Our Enduring and Established Constitutional Heritage Act, prevents US courts from enforcing foreign defamation judgments that don't comport with First Amendment protections. So even if Depp had won his case and then asked American courts to recognize the judgment, the court probably would have rejected his lawsuit. Of course, now Depp has a second bite at the apple, and if he wins, it would be really unusual given his loss in a country with a lower standard for proving defamation. But either way, it's entirely possible that Johnny Depp's career is over, and the jury is out whether that's Amber Heard's fault or not. But the point may not be about winning a legal victory, but about winning a PR victory and rehabilitating Depp's image. And it seems like he's made some progress in that respect. Though the Virginia trial has already turned into a complete circus, I'll have to do another video summarizing all the craziness that has already occurred, including Heard's lawyer objecting to himself and Johnny Depp becoming an expert on hearsay. But if Johnny Depp wins either legally or in the court of public opinion, he should celebrate by making himself a nice meal, which he can do with today's sponsor, HelloFresh. HelloFresh is a great way to eat delicious fresh food while still being healthy. In fact, HelloFresh has a variety of calorie-smart and carb-smart recipes, as well as pescatarian and veggie options, as well as a new Mediterranean line. You can customize it how you'd like. You can swap out proteins or get premium top-of-the-line versions. Now, I'm a do-it-yourself person, and I have to say I was initially pretty skeptical about HelloFresh. I'm a pretty good cook, so I didn't really think I needed the help, but I actually love it. And even for an experienced cook, HelloFresh delivers new ingredients and recipes that I'd never try on my own. HelloFresh generally keeps everyone's favorite meals and then rotates new ones in all the time. Most recently, I've enjoyed seasonal spring recipes like sweet heat shrimp tempura bowls. Try saying that one 3 times fast. Garden spinach ricotta ravioli, also a tongue twister, and one pot creamy lemon dill chicken soup. Now, I don't know about you, but I would never have attempted those on my own, especially just because it's hard to say. But honestly, they are really delicious no matter how hard it is to actually say the titles. And in fact, I usually increase the size of my HelloFresh servings so that I can enjoy the leftovers for lunches and snacks later on. And it's not just meals. HelloFresh's marketplace features a variety of add-ons for breakfast, desserts, and seasonal snacks. Again, huge time savings as well. And of course, everything was delivered straight to my door, so I didn't have to do any shopping. The produce actually gets to you faster than a grocery store, so it arrives at peak freshness and flavor. And all of this saves you time because HelloFresh cuts out meal planning and prep, so the recipes only take 20 to 30 minutes to cook, literally less time to cook than it would normally take to do the shopping for the meal. And it's also really sustainable. Since the ingredients are pre-portioned, there's less prep and less food waste. The packaging is almost entirely made from recyclable or already recycled content. And HelloFresh's carbon footprint is actually 25% lower than that of meals made from store-bought groceries. And it's 72% cheaper than dining at a restaurant. So if you'd like to try HelloFresh, and you really should, you can go to HelloFresh.com and use the code LegalEagle16 for up to 16 free meals and 3 surprise gifts. Yes, you can actually get 16 free meals, and that includes free shipping. All you have to do is click on the link that's on screen right now. So again, for up to 16 free meals and 3 surprise gifts, click on the link that's on screen right now and use the promo code LegalEagle16 when you check out. Plus, clicking on the link really helps out this channel. And while you're at it, click on this playlist with all of my other videos. So click on this link, or I'll see you in court. So it turns out that Fox News was right. There is a Biden crime family, but at the moment it seems to be limited only to President Joe Biden's fail son, Hunter Biden. Yes, Hunter Biden has struck a deal with prosecutors to plead guilty to 2 counts of failing to pay taxes in a timely manner, and the president's son will also complete a pretrial diversion program to resolve a felony gun charge. And as part of that plea agreement, the Justice Department will recommend probation, but a federal judge appointed by Donald Trump will now have the final say in the criminal sentence. And in a statement, the U.S. Attorney David Weiss, also a Trump appointee, said that his investigation of Hunter is ongoing. Joe Biden said he still loves his son, and Republicans are extremely outraged. So basically, there's a little bit for absolutely everyone to hate in this particular agreement. But is this the moment that MAGA has been waiting for, or just more evidence that Joe Biden has weaponized the Justice Department? And what does it mean for the Biden administration to prosecute both his son and a political rival at the same time? Now, the allegations against Hunter Biden have been investigated on 2 tracks, political and legal. On the political side, Republicans have accused Hunter of taking bribes in Ukraine and China in exchange for policy concessions by his father. A Republican Senate committee investigated Hunter's ties to a Ukrainian energy company, but did not identify any policies that were directly affected by Hunter Biden's work. Republicans have also spent several years speculating about the contents of Hunter Biden's laptop.
It's called the laptop from Al.
Their newest allegation is that there is a secret document showing that Hunter and Joe took bribes when Joe was the vice president. Now, much to the chagrin of many of these politicians, the charges here don't have anything to do with those allegations. And as you might recall, in 2018, FBI Director Christopher Wray, who was appointed by Donald Trump, started investigating Hunter's overseas business dealings. The FBI served subpoenas on Hunter and several of his business associates, reportedly looking for evidence regarding foreign lobbying, money laundering, and other crimes. The Hunter probe continued under both of Trump's attorneys general, including Jeff Sessions and William Barr. And the political attacks on Hunter intensified during the 2020 election, while the FBI was continuing the criminal investigation. And after Joe Biden was elected president, he replaced many of the U.S. attorneys appointed by Trump. However, he made an exception for David Weiss, the U.S. attorney in Delaware who was leading the Hunter investigation. Now, presumably Biden thought that it would appear partisan if he fired the lawyer who was investigating his son. Although Weiss was appointed by Trump, his colleagues described him as a fair lawyer who wouldn't be swayed by partisan interests. And Weiss announced criminal charges on June 20th, 2023. Hunter Biden was charged with 2 counts of willful failure to pay income tax in violation of 28 U.S.C. 7203, and Hunter agreed to plead guilty to both counts. The Justice Department also charged Hunter with possession of a firearm by a person who was an unlawful user in violation of 18 U.S.C. 922 and 924. Hunter Biden agreed to enter into a pretrial diversion program for the firearm violation. And reports suggest that Hunter will be sentenced to 2 years of probation, although that will be determined by a judge according to the sentencing guidelines. Now, Hunter's lawyer, Chris Clark, said, quote, "I know Hunter believes it is important to take responsibility for these mistakes he made during a period of turmoil and addiction in his life. He's looking forward to continuing his recovery and moving forward." Joe Biden issued the statement that, quote, "The president and first lady love their son and support him as he continues to rebuild his life. We will have no further comment." Now, on the other side of the aisle, some of the Republicans who had been making hay out of a potential Hunter Biden prosecution basically lost their minds. Senator Josh Hawley said, quote, "So Hunter Biden gets a special plea deal, slap on the wrist, probably won't do a day of time, while the DOJ charges Trump as a spy and tries to put him in prison forever, 2 standards of justice." Now, it's probably worth pointing out that the DOJ has not charged Trump of being a spy, nor is it seeking to put him in jail forever. But let's dig into the Hunter Biden charges. Now, when you buy a firearm, you have to fill out a firearm transaction record, which asks whether you are an unlawful user or addicted to marijuana or any depressant, stimulant, narcotic drug, or any other controlled substance. It is illegal to lie on this form. And in 2018, Hunter's then girlfriend, who happened to be his late brother's widow, threw his revolver into a Wilmington trash can. A few days later, a man found the revolver while going through the dumpster. The Secret Service allegedly demanded that the owner of the gun store where Hunter bought the gun turn over paperwork showing that Hunter purchased it. And instead, the owner turned the paperwork over to the ATF. According to the criminal information, Hunter purchased the Colt Cobra 38 Special revolver sometime in October of 2018. Hunter made the purchase, quote, knowing that he was an unlawful user or addicted to a controlled substance. And when he completed the form, Hunter lied about his history of abusing controlled substances. And the statute makes it illegal for certain people to have firearms or ammunition. The list of prohibited users includes people who are drug users or addicts, and to prove the case, the government just has to show that the person was using illegal drugs. Now, Hunter Biden obviously has a long history of drug addiction, and he admitted to using illegal drugs during the time of the offense.
You're smoking crack around the clock.
This particular offense is punishable by up to 10 years in prison, but as my friend Scowell has pointed out many times, the amount of time that someone gets depends on the federal sentencing guidelines and rarely gets the maximum here. Now, some are not happy that the prosecutor here is recommending pretrial diversion for Hunter Biden on the gun charge, but this is a law that many people don't think is actually constitutional because of the Supreme Court's interpretation of the Second Amendment. And on top of that, it is a rarely prosecuted crime. As one commentator pointed out, the addict in possession of a weapon charge is very rarely brought. It's been used as a catch-all for white supremacists in the past when the feds needed something to stick. And there are several instances where defendants received light sentences, like neo-Nazis who were sentenced to time served, and a January 6th defendant who had a big stash of cannabis when they were arrested. And in fact, several federal courts have concluded that Section 922G is unconstitutional because of the Supreme Court's ruling in the New York State Rifle and Pistol Association versus Bruin case. After Bruin, if the government wants to put restrictions on firearm ownership, it must, quote, affirmatively prove that its firearm regulation is part of the historical tradition that delimits the outer bounds of the right to keep and bear arms. Now, federal courts have wasted no time in declaring parts of Section 922G unconstitutional. In Oklahoma, federal court has actually ruled it's unconstitutional to prohibit people who use illegal drugs from possessing firearms. The government argued that regulating drug users' access to weapons is, quote, consistent with a long-standing historical tradition in America of disarming presumptively risky persons, namely felons, the mentally ill, and the intoxicated. But the court disagreed, ruling that the use of marijuana didn't strip the defendant of his fundamental right to possess a firearm. A Texas district court also ruled that a marijuana user could not be prohibited from accessing a firearm, and Section 922G8 bars people with a history of domestic violence from owning firearms. But in 2022, the Fifth Circuit ruled that people with domestic violence charges have a Second Amendment right to have firearms. And the 3-judge panel wrote that while it would be probably a good thing to stop abusers from having weapons, from a historical perspective, the ban was an outlier where our ancestors would never have accepted. And a few other courts have had similar rulings, but most importantly, on June 6, 2023, the Third Circuit, which includes Delaware, ruled that subsection G1, which prohibits people with prior convictions from owning firearms, is unconstitutional using the same rationale as those other cases. And because of this Bruin case, a domestic violence perp is one of the people who have a constitutional right to bear arms. And while the government appealed these decisions, the momentum is on the side of Second Amendment enthusiasts like Donald Trump Jr. and Hunter Biden. So I guess this brings the Trump and Biden families together in this case. Now, whether they're drug-related or not, devastating injuries and catastrophic events can happen at any time. And the best time to decide which lawyer you're going to reach out to when you or a loved one is injured by someone else's negligence is today, before you're injured. Don't wait until the crisis comes to decide what to do. But if you or a loved one is seriously injured, call my law firm, the Eagle team. We can help. A free consultation is just a phone call away. All you have to do is click on the link down in the description. Now back to Hunter Biden. On top of the gun charges, Hunter is also being charged with failure to pay income tax. The government alleges that Hunter Biden allegedly received more than $1.5 million in taxable income during 2017, and that he owed around $100,000 in income taxes. Hunter did not pay the taxes by April of 2018 as required by federal law, and in 2018, Hunter received more than $1.5 million and failed to pay his taxes by April 2019. Now, as a result, Hunter pleaded guilty on 2 counts of violating 26 U.S.C. 7203, which states, quote, any person required under this title to pay any estimated tax or tax who willfully fails to pay such estimated tax or tax, makes such return, keeps such records, or supply such information at the time or times required by law or regulation, shall, in addition to other penalties provided by law, be guilty of a misdemeanor and, upon conviction thereof, shall be fined not more than $25,000, $100,000 in the case of a corporation, or imprisonment not more than 1 year, or both, together with the costs of prosecution. And the statute goes on to say that any willful violation of that section will be a felony rather than a misdemeanor, and the penalty is 5 years rather than 1 year. Now, Hunter Biden's lawyer told CNN that Hunter Biden struggled financially during those years, despite making millions of dollars because of his addiction, and the lawyer said that he has now fully paid the IRS debts.
He didn't timely pay the taxes he was supposed to pay at the time. He subsequently has paid them.
And those who are mad about this case want to know why Hunter isn't going to get 5 years in prison. And the answer is pretty simple. Prosecutors offered him a deal if he admitted to guilt, and he took that deal. Now, those lawyers that I've spoken to who regularly prosecute or defend these types of crimes indicate that this kind of plea agreement is nothing out of the ordinary based on the allegations that we're seeing. And ironically, it is the gun charge that is much more unusual in the sense that it's rarely ever prosecuted, rather than this particular plea agreement based on the tax charges. But some have pointed out that actor Wesley Snipes got a 3-year sentence for similar tax evasion charges, where Hunter Biden won't spend a night in jail. So what about the Snipes case? Well, Snipes stopped paying all taxes in 1999, quote, after coming into contact with tax advisor Eddie Ray Kahn of the tax protest groups American Rights Litigators and Guiding Light of God Ministries. Kahn convinced Snipes that there was no law imposing taxes on income earned from U.S. sources. Now, this is a nonsense sovereign citizen defense that has repeatedly been debunked by the IRS and dozens of courts, but Snipes ran with that argument and took his case to a trial where a jury found him guilty. And odds are that if Snipes had taken a plea agreement, he probably would have gotten a much lighter sentence. Now, some have also criticized Merrick Garland as going easy on Democratic targets, but also in 2022, Roger Stone settled a tax case with the Department of Justice where he and his wife owed a whopping $2 million in unpaid taxes. But there, Roger Stone was allowed to pay it off with no probation or charges. And prosecutor David Weiss has already responded to allegations that Merrick Garland was calling the shots on the Hunter Biden prosecution. In June of 2023, he replied to Representative Jim Jordan by letter saying that Weiss had been granted, quote, ultimate authority over the Hunter investigation. He also affirmed his ability to make decisions without respect to politics. Quote, throughout my tenure as U.S. Attorney, my decisions have been made, and with respect to the matter, must be made without reference to political considerations. And Garland himself commented on the case, but didn't say much. Quote, as I said from the moment of my appointment as Attorney General, I would leave this matter in the hands of the United States Attorney, who was appointed by the previous president and assigned to this matter by the previous administration. He said Weiss was, quote, given full authority to decide the matter as he decided was appropriate, and that's what he's done. Now, the Hunter Biden crime saga is a complex and nuanced case, which makes it ripe for politicization. Now, news outlets covering the trial can shape people's understanding of the issues depending on the details they focus on and the language they use, which is why I'm excited about today's sponsor, Ground News. Ground News is a great website and app that lets you compare related curated articles in one place from thousands of sources from around the world and across the political spectrum, with context about the source of the information. For example, the big story about Hunter Biden pleading guilty was covered widely by 431 news outlets across the political spectrum. But it really gets interesting when you compare these headlines. Left-leaning articles referred to misdemeanor tax charges, while news outlets on the right referred to it as a sweetheart deal. And both types of sources kept the actual charges vague, so you definitely want to click through and read the entire article. But Ground News digs in with every story and shows that not all of them are evenly reported. For example, the story about a whistleblower testimony released by the GOP was mostly covered by news outlets on the right. And meanwhile, the story about Donald Trump referring to his prosecution as a traffic ticket was mostly covered by the left. And if you look at the factuality ratings for both of these stories, it's not super high, and you'll want to read with caution. And this is just a taste of why Ground News is a fascinating and useful way to read the news, and why it's unlike any other news site out there. So if you want to give it a try, you can use my link and get 30% off their All Access Vantage subscription. Just click on the link that's on screen right now or down in the description. You'll help out independent and transparent news, and if you click on the link below, you'll get 30% off. After that, click on this link over here for more Legal Eagle, or I'll see you in court. Wait, we're calling this video what now? I guess that's one way to put it. Yes, the first criminal trial of a former president in history is now underway. And you know, you don't usually have to tell defendants not to go online and attack the judge's family, but in the case of Donald Trump, apparently you do. Yes, in his ongoing hush money trial in New York, Trump's response to a gag order barring him from attacking witnesses and jurors was to turn his rage against the daughter of Judge Juan Merchan. But will Trump be able to abide by the court's order? Here to tell us that he cannot is chaos lawyer Liz Dye.
Thanks, Devin. Last week, New York Supreme Court Justice Juan Merchan imposed a gag order in Trump's New York criminal case. That's the prosecution for 34 counts of filing false business records to hide the $130,000 payment to adult film actress Stormy Daniels in 2016. Trump's lawyer Michael Cohen fronted the cash and later billed Trump for legal work, which was never performed. During his first year in office, Trump and his son Don Jr. signed monthly checks to pay those sham invoices. Trump tried mightily to wriggle out of this case, including an effort to get it transferred to federal court, various claims of presidential immunity, and accusing the prosecutors of misconduct. But now the court has said there will be no more postponements and set the trial to begin on April 15th. So unless he can find some new and interesting way to throw sand in the gears, the former president will face a jury this month. The New York case is the least dangerous of Trump's 4 pending criminal prosecutions, with jail time unlikely, but it does have the advantage of bringing him face to face with people he absolutely loathes. Donald Trump's list of enemies is long and distinguished. He hates Hillary Clinton, of course, and Rosie O'Donnell, but he also hates windmills, and dogs, and babies.
I think she really believed me that I love having a baby crying while I'm speaking.
Now, Trump is about to be trapped in a room listening to testimony by Stormy Daniels, whom he's sued and been sued by after she broke her confidentiality agreement and told the world about their brief romantic encounter at a Lake Tahoe golf tournament in 2006. Trump despises Daniels and has attacked her on social media for years. Aside from the political damage she inflicted on him, Daniels made derogatory comments about his manhood and claimed that she'd spanked him with a rolled-up copy of Forbes magazine that had a picture of him with Ivanka and Don Jr. on the cover. And Daniels isn't the only witness guaranteed to drive Trump wild. Michael Cohen, who once swore he'd take a bullet for his former boss, has turned into Trump's arch-nemesis. Cohen's testimony to Congress that Trump routinely falsified his business records kicked off the civil fraud investigation in New York, leading to that $464 million fine. Like Daniels, Cohen and Trump have sued each other, and like Daniels, Trump detests Cohen. But there's another person in this courtroom who Trump hates a lot, and that person is Justice Juan Merchan. Because even before he denied all of Trump's motions in this trial, the judge presided over the tax fraud case against the Trump Organization and its longtime chief financial officer, Alan Weisselberg. Weisselberg pled guilty in the scheme to pay himself with pre-tax dollars and stiff Uncle Sam in the New York Revenue Authority. But he steadfastly refused to give up Trump himself. Justice Merchan sentenced Weisselberg to 5 months at Rikers Island Prison, earning Trump's everlasting ire. While admitting that Justice Merchan is a very distinguished-looking man, Trump called him a true and certified Trump hater who suffers from a very serious case of Trump derangement syndrome and who treated Alan Weisselberg viciously. Naturally, Trump has spewed a fire hose of invective at Daniels, Cohen, and Merchan in the lead-up to this trial, which is gross. But it also endangers both the targets of his rage and the integrity of the trial itself. Because brass tacks, who would want to be a witness or sit on a jury if it meant being put on blast to millions of armed, angry MAGA supporters? On February 26, District Attorney Alvin Bragg's office filed a 331-page motion to restrict Trump's extrajudicial statements. In other words, they requested a gag order. Prosecutors pointed to the defendant's long history of making public and inflammatory remarks about participants in various judicial proceedings against him, including jurors, witnesses, lawyers, and court staff. And they pointed to the inevitable reactions they incite from defendants' followers and allies. Prosecutors asked the court to limit Trump's public attacks, which, quote, pose a significant and imminent threat to the orderly administration of this criminal proceeding and a substantial likelihood of causing material prejudice. They also noted the many, many people who have suffered threats and harassment after Trump sicked his supporters on them. From Atlanta poll workers Ruby Freeman and Shay Moss, to former Arizona House Speaker Rusty Bowers, to Fulton County District Attorney Fonnie Willis, to E. Jean Carroll, to Trump's own Vice President Mike Pence. The motion quoted the judge in the E. Jean Carroll defamation cases, who noted that Trump has a long-standing and perhaps singular history of using social media, speeches, rallies, and other public statements to attack individuals that he considers to be adversaries, including courts, judges, various law enforcement officials, and other public officials, and even individual jurors in other matters. The motion referenced a ruling by Judge Chanya Chutkan in Trump's election interference case, who concluded that when defendant has publicly attacked individuals, those individuals are consequently threatened and harassed. And the DA included more than 50 pages of Trump's social media posts to prove the point. Like 3 days after he was indicted in the DC election interference case, when he said, "If you go after me, I'm coming after you." Or when he suggested that people who cooperated with the government were weaklings and cowards and so bad for the future of our failing nation. Or the dozens of times he called Attorney General Letitia James racist and used a word that is this close to a racial slur to describe her. Actually, it's kind of amazing that it wasn't 3,000 pages. After all that, the prosecutors asked the court to bar Trump from speaking about known or reasonably foreseeable witnesses, lawyers in the case other than the district attorney Bragg himself, members of the court staff and the district attorney staff and their family members, and the jurors. Trump's lawyers yelled that the First Amendment under the state and federal constitutions requires that President Trump's ability to respond to public attacks relating to this case as he continues his leading campaign for the presidency be afforded the highest level of constitutional protections. Which is lawyer speak for, our client has a constitutional right to whip his supporters into a rage directed at parties to his criminal case because he's running for president. And Trump's lawyers capped it all off by claiming that gagging Trump because of something his supporters might do is a classic heckler's veto, which the First Amendment categorically forbids. A heckler's veto is when government officials censor a speaker because they fear her speech will spark a protest. The ACLU of Michigan writes, when someone exercises their First Amendment right to free speech, the government is not allowed to shut down the speech just because other people don't like the message that is being conveyed. This is known as the rule against the heckler's veto. It's classically been used to shut down civil rights protests on the theory that they will provoke a violent backlash. Although courts have also ruled that it was a heckler's veto for states to refuse assembly permits to neo-Nazis out of fear that allowing them to march would start a riot. But that's not what's going on here. When a woman named Abigail Jo Schrei called up Judge Chutkan's chambers to spew death threats and racial slurs, she wasn't heckling Donald Trump. She was riled up by his constant screaming about the judge on social media, which Trump's lawyers knew perfectly well. And if they didn't remember it from law school, they knew it because multiple courts have already reminded them of it. The DC Circuit already lectured them in December that this argument misunderstands the heckler's veto doctrine. That doctrine prohibits restraining speech on the grounds that it might offend a hostile mob hearing the message or because its audience might express hostility to the message. The harm that the district court identified here was not that some members of the public who oppose Mr. Trump's message might react violently and try and shut down his speech. The concern was instead how predictable it has become that some, but certainly not all or even many of Mr. Trump's followers will act minaciously in response to his words. But this isn't Trump's first rodeo. So Justice Merchan had a template to work from. In October, Judge Chutkan issued a gag order in the election interference case. She rejected Trump's arguments about the heckler's veto and special First Amendment rights for presidential candidates because equal justice under the law requires equal treatment of criminal defendants, and the defendant's presidential candidacy cannot excuse statements that would otherwise intolerably jeopardize these proceedings. She imposed restrictions on Trump's out-of-court statements to mitigate the significant and immediate risk that witnesses will be intimidated or otherwise unduly influenced by the prospect of being themselves targeted for harassment or threats, and attorneys, public servants, and other court staff will themselves become targets for threats and harassment. Specifically, Judge Chutkan barred Trump from making comments about the prosecutors, court staff, or witnesses in that case. And with a few minor tweaks, the D.C. Circuit affirmed that ruling, which meant that D.A. Bragg did not have to reinvent the wheel in New York and hope that it would pass First Amendment muster. He could just ask for what the D.C. Circuit had already greenlighted and replicate the appellate court's legal reasoning. Bragg's only additional request was an order preventing the defendant from attacking jurors. And luckily, or unluckily, Trump was kind enough to supply the prosecutors with a mountain of evidence there too. In the Fulton County RICO case, he accused the foreperson of the racist DA special grand jury of doing a media tour revealing the grand jury's inner workings and thoughts. After Trump called it an illegal kangaroo court, the grand jurors were doxxed online. And in 2020, when his buddy Roger Stone was convicted by a unanimous jury on 7 counts of obstruction, false statements, and witness tampering, Trump attacked that jury's foreperson as well.
I guess from what I hear, a very strong woman, a very dominant person. So she can get people to do whatever she wants. And she got on, then she became the four-woman on the jury. And they started looking at, now how can you have a jury pool tainted so badly?
The foreperson attested that she'd faced a barrage of harassment and still felt unsafe. Other jurors testified that the threat of being exposed and harassed for jury service creates a situation where people may not be willing to serve as jurors. In fact, Trump's big mouth supplied reams of evidence for the DA, whose motion had sections on the current criminal case, the D.C. case, the New York Attorney General civil fraud action, the Fulton County RICO prosecution, the Atlanta poll workers he harassed, the Roger Stone case, and a general heading on defendants' advocacy of revenge and retribution against perceived opponents. Trump's lawyers responded with the very same arguments that got rejected by the D.C. Circuit. Really? Again with this? And those arguments did not fare any better with Justice Merchan, who noted that he'd held off on issuing a gag order, choosing instead to issue an admonition at the beginning of the case when he cautioned Trump and his lawyers to behave themselves. Instead, Trump attacked Cohen, Daniels, and the DA, as well as the judge himself. So Justice Merchan granted the gag order, after which Trump went silent and started acting like a responsible adult. April Fools! What he actually did was go on a social media bender attacking Justice Merchan's daughter.
Now, I'm sorry to interrupt, Liz, but if you're going to attack the judge's daughter, you probably want a good lawyer. But if you want a great lawyer, my law firm, the Eagle team, can help. If you've suffered a data breach, especially if you've got one of those data breach letters saying your information might have been linked, were in a car crash, or have dealt with sexual harassment from Trump or anyone else, we can help represent you or help find you the right attorney. It's so important to talk to a lawyer right away so you can get the best representation and find out what your options are. So just click on the link in the description or call the number that's on screen for a free consultation with my team. Because you don't just need a legal team, you need the Eagle team. So click on the link below.
But before we get to that, let's talk about the first gag order, which came in the New York civil fraud case after Trump posted a photo of the judge's law clerk online and falsely claimed that she was Senator Chuck Schumer's girlfriend. Attacking a civil servant is beyond inappropriate, not to mention really, really stupid, since judges are hugely protective of their staff. So Trump's lawyers got him to take it down immediately, and they pinky promised to Justice Arthur Engoron that he'd never do it again. But of course, he did do it again. At which point, his lawyers gave up and joined in, making attacks on the clerk central to their claim of judicial bias. When they appealed the gag order, a court safety officer supplied the court with dozens of pages documenting the avalanche of death threats and anti-Semitic abuse that rained down on the judge and his clerk thanks to Trump's social media posts. The appellate panel reinstated the order, after which Trump immediately shifted to attacking Justice Engoron's wife and son, who weren't covered by the order. Based on nothing but rumors on social media, he insisted that an anonymous anti-Trump Twitter account belonged to the judge's wife. And he posted images of a random bald guy sitting in the courtroom declaring that he was Justice Engoron's son, enjoying the perks of access to his father's big trial. None of this was true. Mrs. Engoron does not tweet, and the bald guy was a New York Post reporter. But I bet you can see where this is going. Immediately after the gag order blocking him from attacking Cohen and Daniels, Trump pivoted to attacking the judge and his family. He complained that Judge Juan Merchan, who is suffering from an acute case of Trump derangement syndrome, whose daughter represents crooked Joe Biden, Kamala Harris, Adam Shifty Schiff, and other radical liberals, has just posted a picture of me behind bars, her obvious goal, and makes it completely impossible for me to get a fair trial. Justice Merchan's daughter does indeed run a Democratic political consultancy, but that is not her Twitter account. A court spokesman released a statement confirming that Justice Merchan's daughter had deleted the account a year ago. He said that it was not linked to her email address, nor has she posted under that screen name since she deleted the account. Someone else has picked up the handle and is now manipulating an account she long ago abandoned. But Trump, who ignored the court's denial that Justice Engoron's wife was posting anti-Trump memes, was not concerned about accuracy. So he just kept on yelling that the judge's daughter is allowed to post pictures of her dream of putting me in jail and speculating that the judge is such a hater because his daughter makes money by working to get Trump. And when he rules against me over and over again, he is making her company and her richer and richer. Again, normal people don't behave this way. If you are a criminal defendant, the last person on earth you're trying to annoy is the judge in your case. But Trump is not normal. So he just plowed ahead, knowing full well that it would subject the judge's daughter to a torrent of harassment and threats. And his buddies at Fox News and the New York Post ran stories featuring this woman's name and picture too. On April 1, the DA filed a motion asking the court to either clarify that attacking family members of the judge and the DA is forbidden under the original gag order, or expanding the order to cover family members. They also noted that Trump has gone after DA Bragg's wife as well. Prosecutors wrote that Trump knows what he is doing, and everyone else does too. He has said for decades that he attacks his perceived opponents viciously and violently, both because it is a good feeling and because other people will see you doing it. He promised very recently that if you go after me, I'm coming after you. He is carrying out that promise right now. Now, again, in a normal circumstance, the attorneys here would prostrate themselves before the court and say, "We are so sorry, Your Honor, our client will never do that again. Please do not sanction us." But that's not what happened here. Instead, Trump's lawyers insisted that attacking the judge's family is core political speech, and they argued that Justice Marchand had violated judicial ethics by having the court spokesman make that statement to the press, denying that the Twitter account belonged to his daughter. They claimed that Justice Marchand himself was to blame for having his child doxxed, because if he just recused himself when they'd asked him to, then Trump wouldn't have had to aim his social media rage cannon at the judge and his family. Because if you think about it, spreading lies about the judge's daughter is properly understood as a criticism of the court's prior decision not to recuse itself. Wow. Is it really, though? Unsurprisingly, the judge was not persuaded by this argument. He granted the request to expand the gag order, writing that this pattern of attacking family members of presiding jurists and attorneys assigned to his cases serves no legitimate purpose. It merely injects fear in those assigned or called to participate in the proceedings that not only they, but their family members as well are fair game for defendants' vitriol. The court also threatened that if Trump didn't knock it off, he'd forfeit any statutory right he may have to access juror names if he engages in any conduct that threatens the safety and integrity of the jury or the jury selection process. Since then, Trump has posted links on Truth Social to articles about Justice Marchand's wife and daughter, all but daring the court to react. Rolling Stone reports that Trump is confident that no court will jail him during the campaign. According to a source, he thinks these judges have tried to be tough guys, tried to rattle him, and then it was all talk. He said this time it's the same. He has to show he's not afraid of these people, simple as that. And so far, he's been right. Although it did cost him $500 million in judgments. Guess we'll find out soon if that luck runs out.
Yeah, Trump's trial is officially underway, but true to form, and surprising absolutely no one, he has not stopped talking about this case. On the weekend before the trial, Trump bashed Michael Cohen, Stormy Daniels, and the judge's daughter. So before the jury was impaneled, the prosecution introduced a motion to sanction Trump for the social media posts. And here are the problematic statements. First, Trump said, quote, "Has disgraced attorney and felon Michael Cohen been prosecuted for lying?" Then Trump referred to future witnesses Cohen and Daniels as two sleazebags who have, with their lies and misrepresentations, cost our country dearly. Amazingly, that post was part of a thank you note to disgraced Democratic attorney Michael Avenatti, who is now in federal prison for defrauding his clients, including Stormy Daniels herself. Now, a cynic could conclude that Avenatti changed his tune on Trump because he could really use a Trump pardon. But the gag order prevents Trump from talking about witnesses' participation in the case, and both Cohen and Daniels are expected to be key witnesses for the prosecution. Prosecutor Christopher Conroy argued that Trump, quote, "has demonstrated his willingness to flout the order. He's attacked witnesses in the case." Trump lawyer Todd Blanche argued that the post criticizing Cohen and Daniels don't violate the order because, quote, "it is not as if former President Trump is going off and targeting individuals. He's responding to salacious repeated attacks by these witnesses." And yeah, it's a tightrope between wanting an orderly courtroom and allowing the defendant to have First Amendment rights. Now, after the judge expanded the order to include attacks on his family, Trump continued to repost news articles criticizing Judge Marchand's daughter, and the prosecution is seeking fines of $1,000 for each of the 3 potential violations. Which isn't much, but it makes sense for a nominal punishment, setting the foundation for larger sanctions if the behavior continues. Now, Trump and his lawyers have vowed to fight all gag orders, and Trump campaign spokesman Steve Chung said, quote, "the gag order violates the civil rights of over 100 million Americans who follow President Trump and have a First Amendment right to receive and listen to his speech." Judge Marchand has set a hearing on the motion for Tuesday, April 23rd at 9:30 a.m. Now, if dealing with all those shenanigans makes you want to have a few drinks, I wouldn't blame you. But if you want to feel better the day after, I recommend today's sponsor, ZBiotics. Now, I had a very large birthday recently. Some might even say the big one. Now, ever since, I don't quite bounce back from a night out like I used to. I either have a great night or a great morning, but not both, until I tried ZBiotics before I went out. Now, I have to admit, I was extremely skeptical about ZBiotics. At worst, people hawk colloidal silver, and at best, they promote harmless supplements. But on a friend's recommendation, I decided to try ZBiotics for myself before a Friday night out with friends. I had a tennis match the next morning, so I really needed to be feeling my best. I drank his ZBiotics before my first drink, and the next morning, I honestly felt fantastic. This was all before ZBiotics was ever a sponsor on this channel. But in case you don't know, ZBiotics pre-alcohol probiotic drink is the world's first probiotic designed to tackle rough mornings after drinking. Here's how it works. When you drink, alcohol gets converted into a toxic byproduct in the gut called acetaldehyde. It's generally this byproduct, not dehydration, that's to blame for your rough next day. And ZBiotic produces an enzyme to break this byproduct down. So now every time I have a ZBiotics before drinks, I notice a huge difference the next day. Even after a night out, the next day I can confidently plan on working out or just working without worry. I was honestly shocked that it worked at all. Now, obviously, it's not a miracle worker, but I felt so much better than I would without it. And of course, I want to make this clear, do not drink more than you normally would. This isn't a get out of jail free card. But I genuinely felt better than just pounding a bunch of water before I went to sleep, which is what I would normally do. But try it out for yourself and see how well it works. And you can click on the link below for 15% off at checkout with the code LegalEagle. ZBiotics is backed by a 100% money-back guarantee, so if you're unsatisfied for any reason, they'll refund your money, no questions asked. So give yourself the gift of a good morning and click on the link below to get 15% off with the code LegalEagle. After that, click on this link for more LegalEagle, or I'll see you in court. Yes, Elon claims he's leaving Doge. Or at least he claims he's lessening his time there, and it's totally his choice. He definitely wasn't forced out. Now, Elon came into Doge promising to reduce the federal budget by $2 trillion. But after on his own accounts only cutting a mere $150 billion, and BBC analysis revealed that only $61.5 billion of those claims were itemized, and there's only evidence for $32.5 billion, and other analysis suggests that Doge firings and reduced productivity could lead to a net loss of $135 billion for taxpayers, Elon can now ride off into the sunset with the satisfaction of a job well done. But Musk's departure raises more questions than it answered. Like, for example, who was in charge of Doge? And who's in charge now? Now, you might think the answer was Elon Musk based on all the, direct statements of the president to that effect, but the answer is a lot more complicated and a lot dumber. So who really is the administrator of Doge?